So we're discussing this concept that a Beis Din can be demanded to write down the reason for their decision. That is only true according to Tosfos, which seems how we paskin when the person was compelled to come in front of them, bikfiyah. And that seems to be how the Ramah paskins also. And part of the idea of writing down the reason why you gave a din Torah, we'll see another reason, but one of the reasons is so that the decision potentially could be challenged in a Beis Din Hagadol, in the Great Beis Din. Now the question is, when do we have a right to challenge something in a higher Beis Din? And we're going to discuss that today, but before we get to that, let's look at the tshuva, the Noda B'Yehuda on page 106, Rabbosai, into this entire concept of, do you want a booklet?
No.
Okay.
Fine, thank you. You also by heart? No.
All right, into this entire concept of writing down why the judges rendered a psak. So, Noda B'Yehuda, page 106. He writes a letter, Al Dvar Sheilaso Madayan Tzarach Lodia Me'ezet Tamdan. About his question, he's actually writing this to a dayan in his town. Does the dayan have to write down because of what reason he rendered his decision? Yafeh Hora. He says, Afilu ein bedavar shum tam l'chashto. Even if there's no reason to suspect that the dayan gave a erroneous judgment, nonetheless, you should write down the tainas. If, as the Ramah says in the name of Tosfos, mitchila dam b'kfiyah, if the whole judgment came about because the judges compelled one of the parties to come to them, then ena chinami, he should write it down. And what constitutes compellment? Judging someone when you compel them and therefore you need to write the reason. He says the following thing: unless both parties come together to the Beis Din, classify it as if one of the parties is being compelled, and then if they ask the court to state why they rendered the decision, the court has to. And especially, he says, if one of the litigants wants the reason because they want to go to a Beis Din Hagadol to see if a mistake wasn't made, he says, Uvefrat b'dorenu shatos mitzuya, especially in our generation. This is a generation already of the Noda B'Yehuda, where mistakes are common. Certainly in our generation today. He says, even if a court case comes to a Rav Mumche v'Gadol Ador, it comes before the Gadol Ador. If the two other Dayanim that are joining him are not Gedolei Ador, then still a mistake could be made, and therefore a reason should be stated so it potentially could be challenged at a different Beis Din. He says the only reason that a dayan will be reluctant to write down the reason for his decision, if the dayan knows Shlodon B'Tzedek, that he didn't judge justly, or Bishkaga V'Gasli, or he made a mistake and he's too haughty to admit, I made a mistake in my judgment, then that type of dayan is going to be very hesitant and upset as to having to write the reason for his decision. But otherwise, every dayan should want to write the reason for his decision. So it's interesting that he states that what's the main reason that that one of the litigants could compel the judge, again, if they're summoned, not if they go of their own volition to a court, is because maybe the litigant could challenge a decision in a Beis Din Hagadol. The Shnei Luchos Habris on page 107 brings another reason why a dayan should write the reason, and here he seems to be saying in all cases, not even if one of the parties was compelled, but in all cases, and he's not saying it's a mitzvah, he's saying midah tovah. It's a good practice. That the dayan will write to the guilty party why he rendered the decision as such. Mitzad dina, you're putter to write the reason, unless you're asked. And only then, according to Tosfos, which seems to be how we paskin if it's a type of situation where the litigants didn't come of their own volition, but one of them was summoned. However, tov v'yafeh, it's always good to write the reason why you made your decision. Sheyotzi milev hachayav, that the person who's found guilty will not sit and harbor resentment to the dayan, oh, he judged me unfairly. If he renders a reason, it's less likely to happen. The Torah writes in Parshas Yisro, it brings a pasuk. This is when Yisro talks to Moshe Rabbeinu and tells him to set up a court system. Remember, because Moshe Rabbeinu was judging everybody in Aboka at Arab, Yisro had set up a tiered court system, right? Sorry Alafim, sorry Meo, sorry Chamishim, people are in charge of 1,000 people, right? Are charge of 100, charge of 50, charge of 10, he says, and if you do this, Ishal Makomo Yavo V'Shalom, everybody in their place will come in peace. When you write the reason why you made a decision, Ishal Makomo Yavo V'Shalom, peace reigns. People won't leave upset. Beautiful. Okay? There's he writes a statement based on a Maimar Agadata in Sanhedrin that someone who comes from court should sing and go. Create a situation where people will come out of the court with big smiles. Okay, maybe if you're found guilty, you won't have a big smile. But at least you won't be irritated at the dayan, he judged me unfairly, because after all, he wrote his decision. Now, let's get into this entire conversation about challenging a decision in another Beis Din. Okay? I had a Rebbe who said people go to one Beis Din, then they go to another Beis Din in America. He said they play a game. It's called Beis Din baseball. But the reality is, where is this idea? Can you go to another Beis Din? So, the Sma on page 109 writes, based on the Tshuvas Harash, the Beis Din basar Beis Din lo daiki, that we don't go and investigate what another Beis Din made a decision. A Beis Din makes a decision, zeh zeh. That's it. Now, if there's a blanket toss, we're going to get to that. A blanket mistake. The Pischei Tshuva seems to argue. He brings from the Ridvaz, the Rishon, the Ridvaz, that we don't worry about Beis Din making a mistake. Unless somehow you know for sure, we'll get to that. We don't sit and suspect maybe a Beis Din made a mistake. Uveis Din basar Beis Din lo daike. However, writes the Ridvaz, a Rishon, Hani mili bizmanem, that's going back to the time of the Gemara. Aval ha'inna, but today we can investigate a decision rendered by another Beis Din. Why? We're not so expert in Jewish law anymore. This is already a Rishonim talking, early Achronim, I should say. Forget about today. Hilkach daikinam basar Beis Din. And then the Pischei Tshuva writes, Vim bizmano shala Rashba, and if this was the case in the time of the Rashba, writes the Ridvaz, all the more so in our time. Yeah, and certainly if the Dayan judged the case on his own, even though you could decide to pick one guy to judge on your own, or he's a mumchal rabbim, nonetheless, we do have this principle today that we do investigate one Beis Din after another. Now, the Ridvaz is quoting a Tshuvas Rashba. And then it seems that he wrote in a notation that that's only the case bidin shuzar, when it's clear to the second Beis Din or to someone that this first judgment was bizarre. But if it's not strange, Beis Din lo basar Beis Din lo daiki. Okay, so that's already a discussion already in the Achronim, the early Achronim, the late Rishonim, whether or not one Beis Din should challenge and investigate a psak of another Beis Din. Okay? What's the halacha l'maisa? So let's go to the Tzitz Eliezer. Tzitz Eliezer of Ezer Waldenberg. He was nifter only about 15, 20 years ago. Big posek in the 80s and the 90s in Eretz Yisrael. Towards the 90s, right, never once in a while, but in the 80s, 70s, 80s, massive, one of the Gedolim in Eretz Yisrael. And he wrote a lot about the Beis Din system, particularly in Eretz Yisrael. So what does he write? On page 111, let's read the tshuva. Behaklal shel beidina basar beidina lo daiki. He brings already from the Gemara that one Beis Din doesn't challenge what another Beis Din says. He says, Shona hadavar lachalutin. The matter is absolutely different when we talk about the system in Eretz Yisrael. So how does it work in Eretz Yisrael? Let's first understand how it works. There's something called a Beis Din Ezori Kan Va'aretz. They have regional Batei Dinim in Eretz Yisrael. And this is how it works today, right? There's an actual court system in Eretz Yisrael. There's a Beis Din Haraboni. And as I mentioned before, unlike in America, they have actual enforcement powers that are very serious. They can incarcerate someone, and they do incarcerate people if they don't listen to them. So it's a real system.
They could put someone in jail?
Absolutely.
In what type of jail?
In the Israeli jails. I've been to the Israeli jails. They're not happy places. You don't want to go. Okay?
No computers and weights.
Whatever. Okay. So I was in the jail in Beersheba, where what's his name is kept, by the way. Is a famous.
Yourself.
No, I was visiting people there. I'll tell you who's kept there as a aside. Yigal Amir is kept there. Anybody remember who he is? The guy who assassinated Rabin. He's kept there. So it's a real jail. Okay. So when you talk about the local Beis Dins, when a judge today joins the Rabbonos Harashis, right, to be a judge in a local court, that's under the assumption that their psak could be challenged by the Beis Din Hagadol in Yerushalayim, where there's huge Talmidei Chacham on it. So he says today it's a little bit different. Because when you deal in the time of the Gemara, so Eino Chinami, we have the principle Beis Din Basar, Beis Din Lo Daiki. One Beis Din doesn't challenge another. When we're dealing today they're sitting in court under the understanding that their judgment can be challenged. And everybody is coming to the court. The judges, the plaintiffs, the defendants. Everybody understands when they walk into the courts, it's almost like they're going to court al tanai, or it really is, on the condition, and this Hitz Eliezer says there's enough, that their judgment can be challenged by Beis Din Hagadol. And therefore, what is the reason that the Gemara says Beis Din Basar, Beis Din Lo Daiki? Why do we have this principle? You shouldn't investigate what a Beis Din says. Pashat. Because it would create a zilzal, a denigration to the previous Beis Din. But here that's not a problem in Eretz Yisrael, because everybody knows that there's a system. So the fact that a matter is brought before the Beis Din Hagadol of Yerushalayim does not mean that there's a denigration to a regional Beis Din. This is the Tzitz Eliezer's view. He says, beautiful language. I'm sorry, I can't control myself from reading it. And from here, all the people in our land rely on this. And then he writes, V'gam hacharedim hakitzonium. Even the ultra-Orthodox that are extreme, Mishtamshim b'schozos, use this right. Umagishim arum Beis Din Hagadol, and they go to the Beis Din Hagadol when they want to appeal the decision. Vani Yodeya, and I know va'ed al kach, and I'm a witness that this is what's going on. Okay. And he writes that from various letters, he says this was pashut in various lands in the east and in the west. I'm sorry, referring to Europe. The only country I know where this stuff goes on in the organized system that I'm aware of, maybe in many countries, but one that's famous is the one in England where they do have an actual court system. They don't have enforcement powers like Eretz Yisrael, but they have a real court system over there. Okay? And he writes, someone writes a eyewitness that in Turkey, obviously not today, okay, Turkey's, right, there's no Yid in there anymore to a large extent. But once upon a time, there were a lot of Jews in Turkey. That in Turkey, they had a system of Beis Din Shor. It's important to understand that in Arab countries, the Jews that lived in Arab countries, in terms of their internal affairs, were often given tremendous autonomy to adjudicate their own affairs. The Arabs had their court system, their Sharia system, and they gave a lot of autonomy. I'm not talking about whether it was a happy time or a sad time. That's become a lot of dispute today. But they had, in their own dealings, they had a tremendous amount of autonomy.
The Jews were subservient to them than it was happy times.
Right.
Look at Jewish history. Until
well, by and large.
Arab countries, most of the time, they're
so that's a little whitewashed. That's a little whitewashed, frankly. It's a little revision. That's not so true. There was Mizman Lizman, there were pogroms in Arab countries. I know we associate this not for today. Pogroms with Eastern Europe, somehow imagining that in Arab countries everybody lived happily is Nishkan Emes. There were pogroms, but you are correct that for thousands of years the kids.
Not always.
Not always,
Based
correct.
on, I don't know if you read Pharaoh line 12.
Correct. It was better for them than it was in Europe, but it wasn't all hunky-dory. Trust me. Okay. Okay, and he writes that this went in for a long time, and then he ends off, he's quoting someone, and if the earlier ones that were angels did like this, we that are like humans, certainly we could act in the same way. And that's how he says this idea that we're allowed to appeal a decision. Okay, we're going to stop here. I wish everybody a truly, truly wonderful Shabbos.